Okay. Thanks for the introduction, Matt, and thanks all for being here today. Just a technical correction. Caitlin Thompson is the Chief Legal Officer of NC Realtors, and I don't want her job. She's way more important to me. So just so we're clear about who the Chief Legal Officer is, I'm just a lowly lawyer at a law firm who likes to tinker around with forms, and NC Realtors is fortunate enough to allow me to do that. It's one of the things that we do at my law firm. The other thing that we do, and I was actually doing on the way here today, is the legal hotline. If you're not familiar with that, you have Matt here as a resource. You guys are pretty lucky to have him as a local resource. But if for some reason you can't get a hold of him or whatever, you can call the NC Realtors legal hotline or email us, and we can help you out with the transactions that way or answer forms questions. If you have questions today, we will have a Q&A at the end. But if for some reason I don't get to you or you think of something later, well, you can call the legal hotline or email it, and somebody, it'll be me or one of my 3 partners, will get back to you. Okay? All right. So first, what I want to start with actually is the ncrealtors.org website. Okay? It's on the screen right now. It was redone 2 years ago. It is massively improved. If you're not familiar with it, then you should be. If you hover over this thing right here, and mind you, some of you, it may look different on your screen depending on how large your screen is. This website is, a dynamic website where depending on how big your screen is, it'll look different. You might need to hover over a little bar in order to get the options. But when you hover over legal and ethics, when you find that section, then you can see this little thing called legal Q&As. Every single year, round about this time, we publish Q&As on the summary of forms changes. And you can see right here, we got commercial, we got residential, we got auction, we got property management. And these summaries, our law firm types them out and we prepare them for the executive committee. Basically, they're summaries of everything that was done. We are not covering everything that was done this form cycle. Today, we're just going to focus on the big changes in the residential forms arena. I'm not even going to go over all of those because at some point, I presume you want to leave this room today. I know I do. So I presume if you do, then that's how we're going to do it. In any event, this is the same place where the weekly Q&As that come out in the Monday rundown. If you're not familiar with that newsletter, it comes in your email inbox. Those legal Q&As come out every week, and they are published right here. So if you scroll down a little bit, you can see that they populate. They are sorted by date. But this search bar up here works very well. And you can also sort them by other things like A to Z. Actually, that's it. Just A to Z or by date. In any event, usually the search bar is going to get you where you want to go. So when you click on the summary of forms changes, it looks like this, okay? And on this screen, these are hyperlinks. These little blue things right here, not number 1. Number 1 is just a notice, which is special for this particular form cycle. Just the yellow highlights in this particular Q&A show you where the NAR antitrust settlement changes were made. Now, granted, a lot of them are the same or similar or whatever, so we're not going to cover all of them today. We're just going to cover the main ones, the main things you need to know. The goal of the settlement updates was to make it so that when you use the forms, you're going to be in compliance. That's it. That is going to be true once the new rules go into effect. There may be some things we need to do with your existing agreements. We expect to provide some guidance on that in the next couple of weeks, hopefully with also a form solution if there needs to be one. But that's something that we're looking at based on some of the more recent input we've gotten from NAR and what compliance will look like in the forms arena as far as the settlement. So if you click on these hyperlinks, what do you get? You get these things that have already popped up for you. So in this case, what we got right here, is this 800T? I don't want to do this one first. It's computer. There we go. We'll come back to that. In any event, when you click on the hyperlinks right here, then Form 2T is going to come up and it's going to look like this. It's going to have yellow marks and strikeouts and additions in every single place where there's a change. So that's all we're going to do today. And I have many tabs open. So we will go ahead and dive into it. I will try to keep it round about, half hour, 45 minutes, somewhere in that that arena, just for your own budgeting purposes. This on the first page, we made an edit just to make it a little bit easier to read, using the word is instead of being. I don't know, being is kind of like a lawyerly thing, so it's not really something that needs to be in there. We do that sort of house cleaning as we go through the forms changes. Usually it comes up in a discussion. By the way, before I go too much further, forms changes, this is not like I didn't go up the mountain and then receive word from some higher being and then bring tablets down about these forms changes. Okay, that's not how the process works. Instead, you're looking at what we're going to go through today is a room full of people. And I mean a room full, like 25 people sit on the forms committee. And that's just one of the committees that looks at the forms. But they spend at least a whole day a month, at least. Some of them spend more than that because we'll break out into subcommittees and deal with things. That's how, when we go over the new construction contract, that was basically completely revamped. That was months and months of a subcommittee that worked on that eventually brought it to the full committee in order to be voted on. These people, they travel in from all across the state. They work on this all year. We've already set up forms committee meetings starting in August. So around about the time I educate everybody on the forms changes for this year, we start on next year. So, all right. Just so you know, I am merely a messenger. These are not my changes. If you have things that you want to see in the forms, you can email the legal hotline. And then what I do is I take that to the forms committee for discussion. And then they're the ones who decide eventually what to do with it. Okay? In any event, all right, so this is Form 2T, standard offer to purchase contract. This is the first, I think, material change. And what we've got here is a lot of times, if you got a divorcing couple, you got an estate, you got people like that where the payment of the due diligence fee becomes a problem. For whatever reason, I would tell agents all the time, if they call the hotline, just tell the buyer to make the check out to one seller or the other. As long as you have direction from your client that this is how the seller wants the due diligence be made out, then that's fine. You follow your client's direction. But for whatever reason, there's always a source of conflict. So what we did is we just put it right in the contract. So now, buyer agents have it right here in black and white. If the seller tells you to make it out to somebody other than all the sellers, then just do it. Okay? The listing agent has about as much interest in getting disciplined as you do. Okay? If they're telling you to do it, it's because their client told them that's what they want. So just do it and don't worry about it. There's also a change in Form 101 where your client, your seller, can tell you this in writing as the listing agent. So you can map it out ahead of time, and it's no question about it, and you can move on. All right, moving on to changes to the due diligence period. This looks like a big change, but it's not. It's really just meant to accommodate something you guys are doing already and to make it hopefully a little bit better for risk management purposes. Those of you who are BICs, this is really looking out for you guys, hoping to make it so that your agents are not creating landmines for you to navigate. So now there's a checkbox for the due diligence period. It gives you the ability to do two different things. One, a certain number of days, or a date certain, just like always. And in any event, do not insert NA in any of these blanks. This is not a place you insert NA. If you insert NA, you are going to create all sorts of ambiguity because one party will think that there is no due diligence period, and the other party might think the due diligence period goes all the way to closing. Who's right? Both of them, which is bad for you. Okay? So don't put NA in there. All right? Moving on down.
So if we don't have it, 0 days?
Yes, that's correct. And the question was, if there is no due diligence period, what do you put in there? Either write out no due diligence period or 0 days will also work. This is an interesting little change here in this warning paragraph. This went through about 5 different iterations, to be honest. For such a small change, just so you know, this is a good example of sometimes how things move and shift in the committee. This actually, at one point, this warning box was deleted and completely moved to a different section. In any event, it's really to make clear to a seller that due diligence and inspections go all the way up until closing. Okay, there's just because the due diligence period ends doesn't mean that somehow inspections end. Okay, and so this is really just a change where if you have a seller who's being difficult about this, hopefully this will give you. It was already in here in black and white, but we emphasized it again here in this warning box to just say, he can investigate the property and do due diligence. There's another change coming to make that more clear. So if you have a difficult seller, go ahead and do that. I'm going to skip the part about wetlands, but just know that that is added to something the buyer may want to look at. There's a big discussion about that in watershed. Technically speaking, all properties in a watershed. So, we didn't feel, the committee didn't feel that was something that really needed to be put in there, but the discussion did happen in case you were curious about that. And here we go. So here in paragraph 8, and again, we're still in 2T, the standard offer to purchase contract. In paragraph 8, what we have here is a statement that will hopefully give you a little bit more authority and power when an HOA is involved. A lot of times you're going to have difficulty getting information from an HOA. This gives the closing attorney some limited authority. This was something, another committee that works on these forms is the Joint Forms Task Force. That is a joint committee between NC Realtors and the North Carolina Bar Association, the real property section. These are closing attorneys. This is what they do. They deal with this stuff all day. So sometimes they give input on some of the forms. Not every form goes through them, but this one does. It is a joint form between those two bodies. But the closing attorneys, what they really wanted was the ability to do their own due diligence on the seller's behalf to verify HOA information. So that's, giving them that authority and power in this paragraph. Hopefully that'll make it a little bit easier. But, good luck making HOAs do anything. All we can do is our best on our end, I suppose. This is the change I was talking about just a little bit earlier. We're still in seller obligations right here. Access to the property. The seller has to provide reasonable access through closing or possession of the buyer in order for the buyer to conduct any due diligence, investigations, or inspections. That language is added just to make that clear to the seller. Let's see. This is paragraph 8H, the governmental compliance paragraph. The report that the Forms Committee got from the use of 8H over the years, it pretty much worked as intended. I mean, the intent of it was to give the buyer a little bit more even playing field when the seller has not disclosed something that's lacking in governmental compliance. It was putting the buyers, especially buyers with high due diligence fees, in an impossible scenario, because a lot of times the seller will be able to deliver title, but the buyer's having to basically either forfeit their due diligence fee when the seller's failed to disclose serious permitting issues, especially or like they have to accept the property as is with that, or losing their non-refundable money. It was resulting in a lot of lawsuits, and frankly, it was resulting in a lot of complaints against agents. So 8H is not there just to cause you consternation. 8H is there to hopefully give that buyer a little bit more leverage in appropriate scenarios. We got a report back that 8H worked one time where the seller represented the property was on septic. Well, the septic was a tank in the ground that didn't even have a bottom. So, those sorts of scenarios, I think we can all agree, it's not really fair for the buyer to be told there's a septic and really it's just a straight pipe. Okay. So I think that, hopefully it continues to work as intended. This change in particular, though, it doesn't necessarily affect you that much. But in case you need to explain it to your client or tell your client to go seek legal advice, what this change to paragraph 8H, this small change is meant to just make it clear, which I think was already true, that the buyer has to establish the violation. Okay. And if the buyer can't, they just want to make spacious allegations that have no real foundation, then they're just going to have a problem availing themselves of the advantages of this particular section. So the other thing too is with the changes here, the buyer can't sit on something all the way up until closing and then spring it on the seller last minute. They have to promptly notify the seller of a governmental compliance issue. And if they don't, then I think it makes it more difficult for them to spring that last minute and throw a monkey wrench into the closing.
So based on that wording, does that mean if it's discovered that something was done without a permit?
Oh, yes.
So if that's not disclosed up front, it's discovered something was done without a permit, then they can get the diligence fee back?
Potentially, yes. All right. That is it for the offer to purchase contract. We didn't do, there's been years in the past where 2T gets a substantial edit. This year, it was mostly technical edits, although behind those technical edits, as I explained, a lot of time, thought, effort, and energy went into those. Of course, if you have other questions on that, we can address those whenever. But I'm going to keep on moving on. Next up is the buyer possession before closing agreement. This is a technical change too, but it has to do with paragraph 8H that I just talked about. It wasn't clear before that the buyer's waiving 8H. When the buyer takes possession, they're waiving a lot of different things in this paragraph, right? Paragraph 2, they're waiving due diligence. The seller doesn't provide access anymore. The buyer's really at that point really taking on more of a buyer beware kind of role, okay? So this change here makes it clear that 8H is part of the things that the buyer is waiving. All right, and that is it for that form. Let's see. And I think that's it. Yeah, okay. All right. This is the additional provisions addendum. And in here, it's a small change, but one you might want to know about. There's this parenthetical that, the septic system paragraph was only to be used with Form 2T, which is the offer to purchase contract where there's actually, a dwelling on the property. But a lot of times we would get a question of whether you can use the additional provisions addendum with the vacant land contract if there's septic issues going on. And, this parenthetical made it sound like maybe you couldn't, but honestly, after we looked at it, there's, we couldn't figure out why this parenthetical was here in the first place. And it makes sense to potentially add it. There's no real conflict with the septic provisions in the vacant land contract. There is some septic provisions already in there. But the biggest difference between this section and the vacant land contract and the septic provisions in there is this little blank at the end about when the seller is supposed to complete that. That is really the biggest difference between the two. And so if you want to make sure you get the seller to commit to a date when they're supposed to do the clearing that they're obligated to do, this is the place to do it. It may be something where we would eventually look at adding that to 12T, but right now 12T is still the same, but you could also use the additional provisions addendum to make sure that the seller has a date where they need to do the clearing. All right. This is the next one we got here is the agreement to amend contract, Form 4T. And we have created an additional box. And hopefully you guys find this useful, but it is essentially a very simple way for you to add a buyer. Not to remove a buyer, to add a buyer. Okay, so you just need to add a buyer, check the box, add them in. They're going to be part of the contract. Mind you, this amendment would need to be signed by everybody else to consent to that. But that is the goal. So if you need to add somebody for loan purposes, this will give you an easy way to do that. If you're looking to take a buyer off, that is a different issue that you're still, we're still going to recommend you seek legal counsel for that. But do not forget that, in the offer to purchase a contract, this change was made last year. You don't specify who the deed is going to anymore, right? You have that paragraph that basically says that it's going to go to the seller, but it can also go to one of the sellers, or both the sellers, an LLC of the seller, or trust of the seller, right? You have all those standard things that the contract can be made out to. And then if you got some very strange scenario where you've got to put in a name, fine, put in a name. But otherwise, you're not going to be filling out that section anymore. So when you're adding a buyer, that is something that I think the Forms Committee, from a risk management perspective, felt pretty comfortable about adding a buyer. That has to happen all the time for loan purposes. Taking off a buyer, that's a completely different ball of wax. Yeah.
It says the new buyer agrees to be obligated to all current terms of the contract. If there are additional changes, negotiations, do they have to then sign those for the future? It's not like an additional signature today.
Yeah, correct. The question was the language in this amendment says that the buyer's obligated to all the existing. So if there are further amendments or changes to the contract, they will have to sign off on them like any other buyer. Basically, they're just stepping right in wherever the transaction is at. They slip right in right there. Anything that happens from there on, they're treated like any other buyer.
If there are already two people on all the forms as owner, at that point, would you have to do an additional signatures addendum?
Yeah, you'd probably have to use the additional signatures addendum if you've got more than two people. All right. I believe that's it for this one. Yep, it is. All right, moving on. Ooh, yeah. Hold on. I'm gonna see. Let's see if I can make this a little bit better. This is one of my favorite forms. This is brand new. I'm very excited about this one. And the reason I am excited is because whenever I get this hotline call, it's at minimum a 10-minute conversation. Okay. So I'm hoping that this form will, somewhat limit those conversations. This is a state property flow chart. Now, it's still going to be the case that if you get a state property, you're going to need a seller's attorney involved from the get-go. One preferably that has state experience. Okay. That's not going to change, but you probably are not going to have that lawyer when you are first going out and meeting someone at the property. So who in the world signs these agency agreements? Well, here you go. Follow the flow chart and you hopefully, we'll be able to get there between you and your BIC, or if you need to call the hotline, of course, do so. But we've tried real hard. This is a joint form with the NC Realtors and the Bar Association. So this has had a lot of time and thought put into it. There's also this second page here with a lot of really, really good information about estates. This is a really simple 2-page form that is hopefully going to make your lives a lot easier when it comes to these sorts of properties. I'm not going to go through all of it today. It's a little much to do that, but make sure that you read through it, look at it, and then if you're familiar with it, then you can go ahead and you can print this off and take it out to a listing session with an estate property and be like, all right, so here's what we got. Here's where you guys are at with whether there's a will, not a will, estate open and closed. This is the signatures we need, and then go find a lawyer because we need someone to make sure that all this is good enough for the deed, which may or may not be the case, but at least I think the goal of this estate flow chart is to get you in the ballpark. A lot of times you guys are calling the hotline now, and it's just a circus. You've got you've got a contract, an agency agreement with the estate of so and so, but the estate doesn't own anything. I mean, more than likely, in most cases, the estate doesn't have any property interest. So you have an agency agreement with no one that owns anything. So that's not your fault. It's complicated and it's difficult. So hopefully we'll give you this tool. We'll get beyond that. Just know it's there. That's all I'll say about it for today. But it might be something in the future where we're going to look at that more in depth. All right, moving on to the vacant lot land offer to purchase a contract. And I'm going to scroll down. We got the due diligence period change here again. Okay. We didn't make the due diligence fee change, but I still think that is, I think the advice that's been given before, even without the change, I just don't think it's necessary. If you've got direction from your client, follow, the buyer agent should follow that direction. If the listing agent says, make the check out to so-and-so, that's what my client wants, just do it. Anyway, this is a major change here. And, this is one of those where, you remember my story about how I did not go on the mountain and create these, okay? I did not create this, but hopefully you find it valuable. This is a vacant land disclosure. This works very much like the residential property disclosure statement, which, mind you, the residential property disclosure statement and mineral oil gas rights, both those forms are from the Real Estate Commission, okay? We do not create those, we don't edit those, we don't have anything to do with them other than we make sure they're in the forms library for your convenience. But this is different. This is our form. So what this is, it works the same. You have to give a vacant land disclosure statement. It's new form 142. We'll look at that in just a second. And if the buyer gets it at the time, then basically contract's effective, everything moves forward as it ordinarily does. If the buyer does not get it ahead of time, then the consequence for that is the same as it is for the residential property disclosure statement and mineral oil gas rights now. Okay? And that is this. Essentially, to boil it down, there's a small 3-day window after the effective date where the buyer could terminate and get their due diligence feedback. Okay? That is it. So I get this, I've been getting this call more often, and I don't know if it's because sellers just don't want to fill out the forms or what, but if you have a seller that really doesn't want to give disclosures, then that is the consequence. And you can just tell them that. And if they really don't want to do it, then fine. They don't have to do it. It's not something you have to fight with your client about necessarily. Now, for some of you, maybe firm policy would dictate that that's something you really need. And by the way, it would be a very good firm policy to have, and you may want to be very skeptical. It might be a giant red flag if a seller doesn't want to fill that out. Why? Because you have to disclose material facts. Okay, that your duty doesn't change. And if your client's not willing to give information about the property to anybody, and it's something you really want to think about. Now, that's different than no representation, okay? If they want to fill it out, no representation, okay. Just make sure you're still asking the questions that you need to ask in order to get material fact information. Or at the very minimum, if you get like a red flag that material fact might exist, then you need to go ahead and investigate it and make sure, determine whether there is one or not. In any event, the vacant land disclosure statement, new form 142, it's going to be in the forms library, and this will be the check boxes that you can do. Part of the problem, that this is trying to solve is the fact that vacant land, you just don't get any disclosures or really any real information about it. And so it is something where if a seller chooses to fill it out, they are going to, they're going to give information about a property that may well be valuable. And hold on, there it is. And if they choose not to, fine. But hopefully this will, give buyers some information about vacant land, or at least give them a small window to terminate if the seller chooses not to give it. But if you look at the vacant land disclosure statement, form 142, which I have on the screen here, you can see the seller can still check no representation. So, they may be getting information, they may be not. Yeah.
Why is a MOG not required on vacant land?
So the question is, why is the mineral oil gas rights not required on vacant lot land? Well, I will start by saying this. It is required now because that's in 142. So, there's mineral oil gas rights. I'm going to scroll down in this real quick. You can see this is 3 pages of disclosures, okay? All on vacant land.
Vacant land used to be so easy.
Okay. So it's one of those things where it is definitely going to be part of Form 142. But the reason that the current mineral oil gas rights disclosure from the Real Estate Commission doesn't have to begin with vacant land is because it's all part of the same statutory scheme. And in order for those statutes to even apply, the threshold is 1 to 4 dwelling units on the property. If there's not 1 to 4 dwelling units, it doesn't apply. So if there's 5 or 0, then the statutes just don't apply for disclosure. That's how, if you go to chapter 47E, that's like the first thing right at the top. That this statutory scheme, this chapter applies to 1 to 4 dwelling units.
You just clarify. You said that the disclosure statement is not required as part of the contract if the seller doesn't want to sign it. I just want to make sure.
It's required. It's just the consequences for not filling it out are this 3-day window.
That's all? There are no other consequences?
That's correct.
It's not like that.
That's correct.
But only for 3 days.
That's
it.
That's correct. And it's right in the offer to purchase a contract. I'll tell you. Let's see. That one. If you look at this section of 2T, and what I'm moving to is the section where the buyer makes the representation of whether they got the disclosures or not. So where is that section? Here it is. All right. So it's on the screen now. This is paragraph. Well, I'll just tell you the page. The page is page 7. All right. And so you can see right here, buyer has not received a copy of the residential property disclosure statement and can withdraw or terminate the contract without penalty, including a refund of the due diligence fee. And it's this last part here. When I say it's a 3-day window, that's a little bit of an oversimplification, but it is usually how it works. It's because of this. It's whichever event occurs first. Number 1, end of the 3rd calendar day. Okay. 2, end of the 3rd calendar day following the effective date. Oh, sorry, 3rd calendar day following disclosure statement, 3rd calendar day following the effective date, or settlement or occupancy by buyer in the case of a sale exchange. So at a maximum, 3 days after the effective date is, the last thing because, but it could technically be short, depending on how the circumstances play out, which I don't want to go into those scenarios right now. That is wonky, nerd lawyer talk that is not helpful for today. But anyway, that's where it comes from. And that's why it works the way it does. All right, so we went through that. The vacant land disclosure, I'm just going to cover broadly the sections. First, we got physical aspects. We've got septic, we've got caves, we've got erosion, pipelines, landfills. We got all sorts of stuff. We got a whole, practically a quarter of a page on septic systems. I mean, you can have a lot of fun with this. I mean, this is just so many boxes to check. I mean, I think it's fun. I don't know about you guys. All right. But in all seriousness, I mean, this form is meant to, if you have a buyer, it may well be that a seller may not want to fill this out. They may not want to fill out a form. That's understandable. Fine. Whatever. But if you've got a buyer, I think you really have to make a hard push to make this happen, or be really diligent about the 3-day window and be like, fine, we're just so the minute we sign this contract, we'll be getting into that property and doing our investigations, and we will fully enforce that 3-day window. Put some pressure on the seller. It's what's best for your client. So hopefully this will help you guys do your jobs. And hopefully it will help you, face less pressures from, risk management issues coming up because your clients are telling you this, that, or the other. You didn't get this information. You should have known this. Because I don't know if you guys know this or not, but you are prescient about all properties. You know everything about all properties. Your clients have told you this, right? Yeah. No, I understand that. So hopefully this will help you guys in that arena. Here we have legal land use, going back to Form 142. We just have legal issues, land use issues. There's zoning in here, easements, private roads. There's even some stuff about beaches and access. And then we got riparian buffers in survey and boundary aspects. We have survey plats, drawings available, and things of that nature. The seller can just say whether they have them or not, or have knowledge about them. And then finally, we have agricultural and environmental in sections D and E. And we have junk vehicles. We have all sorts of things. All right. So, and then finally, if there is something to add, some specifics to add, then you can identify the paragraph and then put in something in this line here for the signature page. This is not meant to just add another form. The reason this was created is because the Forms Committee kept getting stories about horror stories about vacant land and the lack of disclosure that goes along with that. Hopefully, this will help cut down on some of those. Because at the end of the day, if it's good for your client, it is good for you. So. That's really what it's about. All right.
Is there a section to possibly replace the owner association disclosure?
Well, the
on
owner,
that one, or will we just still have to have that too?
the owner association disclosure form, you're only going to use that when you're not using the RPOs. If you're filling out an RPOs, you don't have to do that form because there is, that information is in the RPOs, and so there's overlap.
Right, but I'm talking about property and land.
Oh, right. No, yeah.
So now we'll have to have both of those.
Correct. Yeah, I don't think there's any overlap between this form. Let's see. I just want to double check.
That'll be on your
That's
August meeting to
Yeah.
add to this, make it 5 pages.
Yes, absolutely.
We will see if there's any appetite for that. All right, moving on to
I have
the.
a question about this.
Oh yeah.
So since in August, you're gonna start thinking forward to next year's form.
Yeah.
On this one, it would be really great if we could follow the example of the new residential property disclosure with the alternated shaded versus unshaded backgrounds. It would make it a lot easier to read and fill out for sellers. I think that was a fantastic change to the new RP, but it would be great if this could be a similar format. So that it makes better ease of use.
And throw the roof on, through the HOA stuff.
I don't know if there will be stomach with the HOA stuff on there, but I will mention it. And anything that encourages readability, I am all about. So incrementally, I think that's something that we're tackling as we go through each cycle. At least, because this will be coming up on my third cycle. Some of you might know my partner, Will Martin. This used to be his role. And so he did it for a long time. Since I've been on there, that's something that, I've tried to focus a little bit more on. But, at the same time, sometimes depending on the structure of the actual Word document we have to work in, sometimes those issues are a little bit more of a tall order, because basically that means I'm having to go start with a brand new Word document and then move everything over. Anyway, all that is to say, I think that's good feedback, and I will see what I can do. I don't promise anything. I promise nothing. All right, moving on to the residential listing agreement. Mind you, the changes for the settlement happen throughout all forms. So that's why, there's an auction update. But interestingly, auction actually redid their offer to purchase contract. They made a pretty big restructure of that. It used to be that, at an auction, they would get, say, 12, 14 offers, but they'd have to cycle through, 3-4 pages to see, like, basically what are the essential terms of this contract. And what we did is restructured it so that now all the information is on the first page. So now they can just, look at the first page, see all the essential terms, and move on. So any of you do anything in auction territory, just know that changes out there. I'm not going to cover that today, though. Today we're just staying in the residential arena. As far as settlement changes, I'll take a minute to just talk about these, but otherwise, just know that it's throughout the agency forms. The first is that if compensation is going to change from what you've agreed to in the agency agreement, then you're going to have your client agree to something different in writing later. That's been confirmed now. We did this change without knowing this for sure, although, based on the information I had at the time, it just seemed like that's the way they were going, and now it's been confirmed that that is the case. The settlement is, in fact, going to require a separate written agreement with you and your client in order to change compensation. You can amend your agency agreement, and there's several different ways to do that, okay? And we'll talk about those a little bit today. But just so you know, make sure that when you are signing the agency agreement with your client, number one, you're putting a specific value. This is for buyers and for sellers. Why? Because the license law tells you have to. So don't argue with me about it. It's a because I said so situation, okay? And then number two is that make sure that when you are deciding, what your compensation is going to be with your client, that it's something that you value your services, you're willing to work for this amount. And don't get, excited just because there's a prospect for something more. If your client's not going to agree to it, then you're not going to agree to it. On the buy side, we have whole antitrust cases that have not been settled yet. They're still pending in Chicago. When I say we, I mean, the National Association of Realtors. And those lawsuits are all about buyers saying, hey, I had an agreement with you. And then you went and got more money from the MLS than what we agreed to in my agency agreement. And when I purchased the property, that money came from me. It went from me to the listing agent to you, but you got paid more than what I agreed to pay you. That's what those cases are about. And so that's part of the reason why this would be a slight shift for us. There'll be a major shift for other states, but not necessarily for North Carolina. But just I've been trying to preach this. If you've already heard me say this 5 times, I apologize. But make sure you are valuing your services when you fill out your agency agreement. And then, if something else comes up that's beneficial, great. But just make sure you put your client first, and make sure that as part of any process of compensation, that is your fixed priority. As far as this language here about the amount, format, or rate of real estate compensation is not fixed by law, but is set by each broker individually and fully negotiable. That means exactly what it says. It doesn't track exactly what the settlement says. The settlement basically says that the first part is that the compensation is not fixed by law and is fully negotiable. That's what the settlement says. However, I was just on a call this week. We got clarification from NAR that language like this that is not exactly on point is still going to be acceptable. And to me, this language is much better than what the settlement provides, because I don't think any part of this, it requires you to value your services any different than what you've already done. You are, now I don't work for free. I presume you don't either. And I presume you like the freedom to be able to work for a rate that you believe you're worth. And so I don't think that's changed. So to say that it's fully negotiable, that may or may not be the case. You may not be willing to work for less. And so I've said it before and I'll say it again. That's when I say that no is part of any negotiation, that's exactly what I mean. If you make an offer on a house, the seller's response could very well be no. That's it. Sorry. Negotiation over. Okay. That can happen. And that can happen with your agency agreements too. It may be that you're willing to do something else, depending on the client. Okay, fine. But if your client's like, all right, well, I know you want to work for X, but I want to basically give you peanuts. Well, no, you don't have to work for peanuts just because that's what your client's asking for. No is part of a negotiation. So this language is in here to make sure that you're in compliance with that part of the settlement. As far as, I think it fits with our practice already. Now you notice that there's not a change in paragraph 8 right here on the screen. But I'm going to take a minute to talk about this because I've got some questions about it and we might as well cover it while we're here. What this says, you have to look at this language carefully, okay? Paragraph 8, this is the part where your seller client is, saying, all right, how much are we paying cooperative compensation, okay? All right. So, firm has advised seller of firm's company policies regarding cooperation and the amount of compensation offered of the brokers, including but limited to, et cetera, et cetera. Seller, and then the last sentence says, seller authorizes firm to blank. And then you check the boxes, offer cooperative compensation to, sub-agents, buyer agents, those check boxes. Or the third check box, which I think a lot of firms may well start using more often, which is fine. That's why that's there. If you have your own policies or different policies about what's going on, then you can just check this box. And the important part to me is, the question, let me start with the question. The question that's been posed to me is, if the seller fills this out and says that we're going to do, X percent to a buyer agent, do I have to offer that? The answer is no. You are authorized to. That doesn't mean you have to. This language is not mandatory, okay? So there's been a lot of questions, especially it seems from buyer agents, because they're just like, well, how do I verify if the listing agent is actually offering me the amount of compensation they agreed to with the seller? That is not your concern as the buyer agent. Sorry, not your relationship at all. And so the listing agent has authority to offer a certain amount, but that doesn't mean they have to. And furthermore, and I think this is also important too, is that if there's a change, then firm says that they are going to inform the client about it. So just make sure that you understand that too. And that's that last paragraph right underneath the third checkbox, okay? And that language there says that if you're going to change, you have authority for a certain amount, but if it changes, you're going to let the seller know, and they're going to agree to it in writing, okay? This is no change to what should have already been going on, and I'm sure everyone in this room is doing it perfectly already. I love preaching to choirs. Just kidding. It's okay.
Can I make another readability suggestion?
No.
It just, the way it's formatted, there's not a space there, makes it seem that long paragraph is part of that third checkbox and not overall for that whole section. So
yeah. Listen, this paragraph is going to get tinkered with this coming cycle. It was one of those things where, we had like major burning fires to put out, and this was not one of them. But this cycle, yes, paragraph 8. The things I'm talking about, I think, are already there. And I think that if this ended up in court, it would be pretty clear that that paragraph is not referencing any of the checkboxes. It applies to the whole paragraph. But at the same time, I think readability, I think you're right on that. That's correct.
Can you give me an example of what that means? Why does someone do that?
Yeah, I mean, let's say you're filling it out. Your seller says, I'm open to offering X percent to a buyer agent. So you fill this section out, you check the first box, you put in whatever percent in there, and then, you move on. And then you go out and you have to understand something. The real change is going to be the very first step that ordinarily you would do is go put the listing in the MLS, and then the offer of cooperative compensation goes out, right? Well, that's not happening, right?
Right.
Not happening in the MLS. Maybe your firm will have something else that it does. But I think the real question in my mind is whether, how often are firms going to be making blanket offers of cooperative compensation? How often is that actually in the seller's best interest? Because it may not be in the seller's best interest. Maybe it is, or maybe it's not. And so really I think that as far as what I'm telling you in this example, the seller signs this, you go out, the buyer agent, sends you an offer. And that offer does not comport with the amount of percentage that the seller's done. It's just not, let's say the offer is just not good enough. And good enough in a way where it would make financial sense for the seller to pay whatever amount you've put into this paragraph here. Then I think you would be like, all right, well, listen, seller, we got this offer, it's close, but we got to adjust, compensation to make it work. So it's just not offered. Yeah, I think that's a good question. Could you do it before? I think you probably could. I just think it wasn't something people thought about.
When MLS has said that there was a box about variable rate commission,
Mhm.
but that had to be checked.
Variable rate is a different thing that we're not getting into today. But the language is the same now as it's always been. Yeah.
Before they can see the offer.
No. We wrote a Q&A on this a couple weeks ago. You can send it at the same time. Or 220 can be after. I mean, I don't recommend that because once you have a contract, what is the real incentive to do cooperative compensation? But maybe there could be. But no, as far as when Form 220, which we haven't got to yet, but as far as when cooperative compensation can be agreed to, it can be before, during, after, same time, anytime.
So as a buyer's agent, it would be smart to not submit that first.
Oh, yes. If you're a buyer agent,
For actual practice purposes, you're gonna submit it first prior to knowing what your offer is, correct? That would be what most people will do.
I presume so, yes. The question was, as a buyer agent, when are you going to submit, when are you going to submit or ask about cooperative compensation? Yes, I imagine most buyer agents are going to be doing that prior to the offer being made. Right.
So then as the listing agent, you say, I'm not gonna tell you to submit your offer.
If the listing agent,
Until you submit your offer with a request.
sure. And if the listing agent says, I'm not discussing that until I see your offer, then you would submit both at the same time. And maybe you would submit the offer without your client's signature on it so that, the issue of cooperative compensation can be worked out. Yeah. I can tell you this, in my view, in a perfect world, cooperative compensation or all of the compensation would just be in the offer to purchase contract. Okay. That would be my preference for simplicity and everything else. The real estate commission has made it very clear they're not changing the rule. So that's not our rule. It's nothing we can do about that. It just is going to be something to navigate in North Carolina where they want compensation, agent compensation, and the offer to purchase contract are two separate things. And you can submit them at the same time. That's fine. But as far as the contractual obligations, the real estate commission wants it to be two completely separate contracts.
But if we're not party to the contract, obviously, we submit them at the same time, the seller signs the offer, it ignores the money.
So this was covered in the Q&A. If you haven't read the Q&A from a couple weeks ago, here, actually, I'll show it on the screen. Just so
Watch out for that.
oh, here we go. Yeah, sorry. So this Q&A on May 23rd, I'm not going to get too far into that. I'm here today for forms changes, but this navigating cooperative compensation in compliance with the license law and the code of ethics. This is a very long Q&A that goes into all these questions. And so I would encourage you to read that and then bother Matt.
Hey, you just extolled the virtues of the legal hotline.
All right, back to Form 101. Let's keep going through the changes.
I have a question on the you don't mind?
Yes.
Can you please explain that one more time? What I heard, but not be correct. So you saying that
we put a price there that's expected for buyer agent publication, but that listing agent can change that without notifying, or if they have the authority to change that?
No, if it's gonna get changed, it has to be done with the consent of the seller. But I'm just saying, you know, you don't have to sign this and go out and start advertising a certain amount of cooperative compensation. That is not how this is written. That is not something that you have to do. There's no language in here that says a listing agent has to go offer a cooperative compensation just because there's something filled out in paragraph 8. Now, will they? Yeah, they may well. I don't know. Honestly, the real issue here is I do not have a crystal ball for what imaginative things you guys are going to come up with after August 17th. Okay? I just don't. If I had that, I could make a lot of money.
You want us to tell you what we're planning?
It would also be the subject of a horror movie. So, like, you know, I don't know what you all are going to do to navigate these waters. What I do know is that, you know, generally speaking, my experience with realtors is you focus on your clients, focus on relationships, and buying and selling property. Everything else, you know, kind of like is details to be worked out, but you guys work them out. And so I don't know what the landscape will be exactly once the new MLS rules go into effect. That will be up to you guys. My job is just to tell you what's already here, you know, potential solutions and things like that. But generally speaking, I think, you know, listing agents are probably going to be filling out this section a lot different with their clients. That could happen, or maybe they won't. I don't know. But what I do know is that there's nothing in here that mandates that a listing firm go out and, you know, put whatever, you know, percentages in this paragraph. That's just not the case. It's not how this is written. Yeah. Maybe the biggest component though that I will add is that we haven't discussed yet is that part of the Q&A talks about how when you if you email an offer and then you have, you know, a cooperative compensation agreement at 220 going along with the offer, then you can explain in the email that the offer is contingent on the cooperative compensation agreement. I think the real estate commission has said that that's okay. So we are going with that. And that is something where maybe we can get a forms change about that eventually, but, you know, there was too many moving parts to put that in for a forms change, at least for the July 1st rollout. So just so you know, that's something we'll be looking at this year, but at the same time, something that's, you know, permissible. You know, it's in the Q&A. I think the Q&A will give you a pretty good roadmap for that. And like I said, you guys will, you know, do whatever you do, you know, come August 17th. And I think you will see some practice changes. And then lo and behold, probably one day this will all be uninteresting. But for now, it's very interesting. In any event. All right, moving on. This change here is just an extra initial alliance so that the seller understands that cooperative compensation is not an obligation. This was actually added prior to the settlement. It was just an extra CYA that the forms committee put in there. All right, this is the part that I was telling you about earlier. It's right here in paragraph 11B, where the seller can tell the listing agent how they want the due diligence fee made out. So that's right here. Disclosures about wetlands and things like that. You know, there's an extra section here for the seller to make disclosures on that. And we added this in a couple different places. We're going to have the buyer and the seller make a disclosure to their agents about whether they're working with a relocation company. You know, this is obviously information you guys want sooner rather than later. So we added that to make sure that you guys are getting that information in a timely manner, preferably at the beginning, so you can decide whether you want to deal with the hassle or not. I know I've heard, talk about horror stories. I've heard some horror stories with relocation companies. All right. We got another new form here. This is form 170. It is one page, but hopefully it will be a valuable tool so that when you're a listing agent, you can hand this to the seller. It's got little check boxes on the side. It's everything they need to do to get out of the house. Okay. So feel free to give them that and harp them about it, you know, and you can just say, listen, not my fault, not my fault. You signed the contract, not me. All right, moving on to Form 201. we broke this paragraph here, this bold part at the beginning. You can see most of it was already in there, but you know, it might be a paragraph that you skipped a bunch of times, but there's actually some important information in here. So we broke it out into, you know, Romanet 1 through 4. Okay. And we added number 4 for relocation company. Like I already said, you know, that's something that we felt was important to add. The forms committee felt was important to add. But also the other things in here are pretty important too. So look at those and, you know, hopefully they'll help make it more clear to the client. Paragraph 4, the compensation, the buyer agent compensation. This is, you know, standard form 201 is the standard form buyer agency agreement. As I said, you know, this section here has always been, this blank here in part B, where you put down what specifically you are getting paid by the buyer has always been required. If you've been putting per MLS or things like that, then you've not been in compliance for quite some time. Okay, it is time to stop, because if you don't stop doing that, you know, come after August 17th, you're going to be very disappointed with the amount you get paid at the closing table. Okay, so make sure that, especially if you're a BIC, make sure you are stressing to your agents that they need to fill this out with a specific amount of compensation.
I have a question about that.
Yeah.
How do you suggest putting in a variety of scenarios? For example, I've agreed with my buyer client that if a property is in a certain price range, my commission will be X, but if it's in another price range, my commission will be Y.
That is 100% spot on. The question was, you know, how do you put in a variable rate? Like if it's a certain amount, a price of home, then it's a certain percentage. If it's a different price of a home, another range, a certain percentage. I think that's perfectly fine. That is a specific amount of money that is easily identifiable, so your client knows exactly what you're going to be paid given the price of the house. So I would actually, depending on how long that list is, if this blank is not enough, you can just do see attached. And then just attach, you know, and you can draft your own attachment for that. These agency agreements are agreements between you and your client. So you are a party to the agreement. Now, there's definitely times where you're going to want a lawyer help you do changes or addendums to these agency agreements, but otherwise you're perfectly entitled to draft whatever you want. You're not drafting for someone else, you're drafting for you. So the agency agreements are an exception to the practicing law without a license. You know, it's not an offer to purchase a contract, which I think all of you understand. You're not going to touch with a 10-foot pole any addendum that's not standard to the offer to purchase a contract. All right, moving down, these changes here are really focused on just NAR, antitrust settlement compliance. And the biggest thing is that, you know, now if there's an offer of cooperative compensation, you know, even if it's outside the MLS, if it's more than what you've agreed to, then your client has to specifically, you know, agree to that. So that's number one. The default language used to be that you could just have that extra compensation. That is no longer the case. Your client has to agree to that in writing. The easiest way to do it might be to go ahead and amend your agency agreement. So you can do that. That's Form 710 or Form 770. There's a small edit to that to make sure your client shows that their consent. We got some extra initial lines here so the buyer understands how the money flows in the transaction. That's, again, that was added before the settlement, and yeah, it just is an extra CYA. The note here has been updated for the NAR settlement to show that Form 770 can be used to disclose additional compensation and get buyer's consent. Form 220 can also be used. You know, there's a note there as far as the listing firm goes, or as we will talk about with Form 220, you can also make an agreement directly with the seller for cooperative compensation if it makes it easier for the listing agent's paperwork. All right, let's see. I can't think. I think that's it. Yeah, that's it for that one.
Before you go off that, I saw it says no range, which is news to me because we have been told previously you could put a range of percentage. So could you say I charge X percent and I'm willing to reduce that to what percentage the seller is offering to you know, a minimum of X?
Well, there's already standard language that says that, you know, you are authorized to seek cooperative compensation from the seller.
Yeah.
There's two ways. It's MLS compliance policy, but it's already been the licensed law for a long time.
So we just want to make sure we're not writing something in that's in violation. So
I don't think it's a violation, but I think it's something where if you put language in there, you just can't put language in there that would indicate that it's somehow a range or variable or dependent on cooperative compensation. Any language along those lines is simply not going to be compliant. I don't know what else to say about it. It's just not. No.
But you're saying if there's price points of the home and different percentages based on the price point of the home, that is legal.
Yes, like if you want to, if you got like ranges of prices of houses and then, different, percentage based on the price range of the house, yes, that's fine. That you can identify specifically how much you're getting paid in that scenario. All right. Also, just in case, for extra fun, the paragraph 14F of the standard for buyer agreement, there's another blank here where you cannot put a range. So we could have the discussion all over again if you like. Just kidding. Don't do that. Dual agency compensation is the same. It's the same rule. Okay, you've got to have an identifiable specific amount. The same disclaimer language is right there, and it hasn't been changed. And again, license law, and now also NAR settlement. So MLS policy will also dictate that. Okay, so moving on, there's not a lot of changes. This is the non-exclusive buyer agency agreement, okay, Form 203. I'm not going to cover the actual changes. I just want to highlight this form. So you may have heard about these, like touring agreements or things like that. We've got some more recent guidance, and we're gonna have to write a Q&A on this. So you guys are like the first telling this too. But these touring agreements, they're actually just agency agreements. Like there's not some special new form that's going to come into existence that is going to be compliant with the NAR settlement policy. So, to the extent that you want to call it a touring agreement or something like that, or have one drafted or whatever, ultimately it's going to end up being an agency agreement. Now, we knew that already in part because Matt wrote me a nastygram after one of my Q&As and told me about, how the Zillow touring agreement Q&A was incorrect. But so anyway, that Q&A has been suspended while Zillow and the Real Estate Commission talk about what a touring agreement would be compliant. But even since then, in that conversation, as far as the NAR settlement terms are, in and of themselves, really, a touring agreement is just not an accurate way to phrase it. What they're really looking for is an agency agreement before you enter the property with the client. And so the reason I bring up Form 203 is because this was what my original thought was. And actually, more the Q&A that got taken down, the broader point I wanted to make was that Form 203 is really the best fit. If you got a client that doesn't really want to like commit all the way to exclusive agency or whatever, but you want the authority to be able to show them the house and do things for them that would ordinarily go along with that, this is a real good form. It's tried and tested. A lot of firms already use it. So it's something that you may have seen already, depending on where, what your firm policy is on that. But if you are looking for a touring agreement, you certainly can have your own drafted if you want. Otherwise, personally, if agents are going to ask me what I think the best thing is, it's going to be Form 203 if you got someone who really wants to see a property, but they don't want to commit to exclusive agency. This is a safe harbor. It is, from a risk management perspective, there's zero doubt in my mind that this is better than anything else that you can have. Or if you do get your own drafted, it's probably going to look a lot like this anyway. I expect Form 203 to go through at least some revisions this year to, like I said, accommodate whatever creative things you guys come up with as far as this new landscape goes. So anyway, I just wanted to put that out there. It's been obviously modified to be compliant with the NAR settlement terms. And so it'll be ready for you to use in those sorts of situations. All right, moving on to Form 220. Old 220 is dead, and we revised it to this. This is supposed to be hopefully a Swiss Army knife, to navigate cooperative compensation. You can do it with the listing firm, you can do it with the seller directly, and then also on here it has the ability for the buyer to sign acknowledging consent to cooperative compensation that you've been able to reach. It's got some nifty little lawyer language here, paragraph 4, to make sure that if it ends up in court, then, all your little side conversations about all this stuff don't end up coming in and ruining your ability to get paid. And then finally, paragraph 2 is really meant to hold the seller's feet to the fire so that they don't try to weasel out last minute. They're going to be obligated to pay if they, breach at the last minute to close the table or something like that. So, hopefully we kept this simple enough so that you guys can use it and not have to think about it too much. Like I said, right now we don't have some sort of form to show that, an offer to purchase a contract for the land is dependent on a Form 220. But I think you can put that language in an email and it will operate as intended. Yeah.
Do you think that we could put X% or as modified by offer of cooperative compensation in the buyer agent fee, which is basically saying that we can modify it on a case-by-case basis, right?
I'm not sure I'm following. Are you talking about Form 201? You're talking about the exclusive buyer agency agreement?
Yeah, we put X% or as modified by offer in the Form 2. Right.
Yeah, no.
No.
And that's explicitly in the NAR settlement terms. You cannot make your compensation with your buyer dependent on cooperative compensation. So any language like that is simply not going to be compliant with MLS policy. All right. This is the Form 350, the unilateral termination form. It used to be, you can see this release of earnest money. This is the second page of the form. It used to be that the seller would consent to whatever reasons the buyer's giving. It's been updated to show that that's not the case, since now, we had these new checkboxes added where buyer doesn't give a reason, or a buyer says that there's been a breach of the contract or something like that. So this hopefully will make it easy so that even if a seller disagrees with the reason the buyer's giving for terminating, that if they want to release the earnest money deposit anyway, that they could do so. So just know that that language is there, and know that the current language in 350 may be problematic for some sellers in some circumstances. So just be aware that it's there. Form 770, as we talked about already, if it turns out, you need a simple form for your client to consent to more compensation, especially on the buyer side, it's additional compensation, but it can work on the seller side too if it's out there. In different markets, I think, right now, I think we're still primarily in a seller market. But if it changes to a buyer market, then you may have, situations where it becomes more often where the seller might have additional compensation for one reason or another. In any event, Form 770 is meant to disclose the additional compensation, and then you can see this line here where your client actually consents to that compensation. And if they don't sign it, then it's just not going to work. You can also, like I said, use the agency amendment form.
Is that one on a case-by-case basis per property, or can that be something that's signed with the agency?
That would be on a case-by-case basis. But yeah, the question is, would 770 be like case-by-case per property, or would you do it at the beginning, like with the agency agreement? And the answer is case-by-case. Yeah, I don't think it's something you would necessarily fill out the beginning. You wouldn't know about additional compensation. I guess if you do know about it at the beginning, you can. But then why wouldn't you just put it into the buyer agency itself? Form 780, this is the overview of the standard form contract. So overview of 2T. This is also the form that is translated into Spanish for 2T. There was a lot of edits to this form. Now, I'm not going over all of them today, but these edits are meant to make it, make the process easier for your client to understand. So just know that 780 had a big rewrite, and that I think it's currently being translated in Spanish. I think that'll be done by July 1st. I hope it will be. We will see.
Notice your page numbers there. It says 6 of 5 and 7 of 5 on those.
Oh, that's because of the strikeouts and markups. Like, you can ignore page numbers. When we do final proofing after this, we make sure that when it gets in zip forms, it's right. And then finally, we got 800T. This is the new construction offer to purchase a contract. As I said at the beginning, this form was substantially rewritten. And we're going to start with, there's no more building deposit. They're going to be called construction fees. Why? because that's generally what they're called in the industry. Like, so we're trying to make the form reflect what's already out there. This section here, it really is meant to stress that you got to make sure you have real thorough plans and specifications for a new house. And the reason for that is because if there's going to be changes, they got to be in writing and agreed to between the parties, even with plans and specifications, or at least anything material. So that's later on in the agreement, but just make sure you do not skip over this section. As it said, they must be listed below with copies attached. So make sure, especially if you're a BIC, that your agents are doing that and that you're supervising that. Construction fees, instead of just having, agents willy-nilly pick whenever these fees might be due, construction fees are still non-refundable, but you can see in this paragraph here, there is a mechanism where they could be if the builder's in breach or something like that, okay? So just pay attention to that. There's some demand language there that you got to follow and things like that. There's also a demand feature for the builder if it's not paid on time, where the buyer may end up being in breach. The triggering events have now been standardized, and so hopefully that'll make it a lot easier for your agents to figure out, all right, we want to pay this much money, during this time. Now, mind you, these are, sort of meant to kind of mirror draws in a new construction loan, but not exactly necessarily. And also, these are not meant to be something where they're meant to fund the entire construction of the home. That continues to remain the same. That was the guidance before with building deposits. That guidance is still the same. This paragraph for substantial completion has been moved, but the biggest thing is this date here for substantial completion. What we've done all through the form is tighten up the dates so that builders cannot just delay forever and ever and ever, when the property being constructed. They are going to be held to dates in the contract. Now there's delays built in, but those delays are standardized, and we'll go through those in a minute. The first date, though, the substantial completion date, is an important date. There are some delays to it, but it is as far as a date, it's an important date in the contract, so make sure you're paying attention to that. Settlement date, there is a 14-day delay, but otherwise settlement's pretty much staying the same. Moving on down. The condition section has been substantially rewritten. These things can be either applicable or not applicable. But if you're a buyer, most of these, you're going to want them to be applicable, especially down here. When it comes to the reports, you're talking about soil suitability, utilities, environmental, flood hazards, all, septic, all these things. These are important things for a buyer. If a seller's not willing to agree to give you these reports, then you need to make a real, you need to have a heart-to-heart with your client about whether this is the right property for them or not. And if so, what kind of risks they might be encountering if they don't get these reports. Here we have the delay in construction paragraph has been slightly edited, but the biggest edit is the small one here. We're now, it's a 60-day hard and fast delay in construction. You're not getting more than 2 months. That's it. So the delay in construction, fine, but you're not getting more than 2 months. It's a big change. Seller, there are builders and sellers who are delaying for 6 months, a year, more. No more of that. It really ties them down much sooner in the process. Buyer investigation. That's pretty much remains the same. I'll skip that for now. But at least it provides for that. I saw a construction contract, a custom one from the builder just yesterday on the hotline where the client basically had no right to get in the property at all. It was not a fun contract for that buyer. All right, there's no delay in settlement, not to exceed 30 days. Mind you, these, I'm not sure there's like a perfect number of days for these delays that are built in, but they are meant to try to be fair to the builder and the buyer at the same time, and not the builder delay indefinitely settlement and construction of the home. All right, this little change here makes it clear that the warranty here is in addition to the ones implied in the law. And I'm not getting into those too much today, but there are essentially 6 important builder warranties that go to the first-time home buyer that the North Carolina Supreme Court, as far as I can tell, created out of thin air years ago. So, but they're there, they're enforceable. I've used them in a lawsuit, so they definitely work. Insulation has been, this is just a formatting change, so otherwise that stays the same. And I think that's about it as far as big changes for this form. So as far as like the rest of this boilerplate, no big changes. The big changes you gotta be aware of are the construction fees, the triggering events, and the fact that, there's these now more firm deadlines for the builders so they cannot delay indefinitely. That way your client knows what's going on. I think that's it. That is 800T again. We don't need to do that. All right. Thank you for coming to my TED Talk. And do you have any?
Any final questions?
Yeah, look, we'll keep it short, but final questions. Yeah.
I have a question is, if you have a listing now, it comes around when the rules change, do we have to update all the listing agreements or?
Yeah, so the question is, are we going to have to update listing agreements? And that's something I'm looking at right now. I think the answer is yes, but I don't think it's going to be I don't think it's going to be a super big deal. If your client's willing to just sign a new compliant form, sure, go ahead and do that. That's certainly an easy way to solve it. But I'm looking at a couple different ways too, where we might need to do some amendments to existing agency agreements. Yeah.
When are the new forms out and when do we have to start using them by?
So July 1st is when the new forms come out. You have 60 days, to use the old forms, which may well be. You have to understand that not every MLS is going to implement everything all at the same time. Okay. August 17th is like, the drop dead date, but some might do it sooner, some later. So it may well be, depending on how that goes, you will, during that 60-day grace period, be using the old forms, even though the new forms are out. Or you may just switch to the new forms just because it makes more sense. There's not necessarily a right, a black and white, right or wrong on that. A lot of people are just going to have to, make that judgment call as we plow through this.
So you're saying that we have to use a new form to update the agreement for the listing comes around July 1st with the old listing?
You can, yes. You don't have to, but yes, you can. Yes, you had a question.
Would it be possible to get seller paid closing costs put on page 1 of the offer of purchase?
I think that's a good question. That's
all
a,
money's in the same place.
Yeah.
Especially now with seller compensation.
no, I think that's a good point. I hadn't heard that yet, but that makes sense. That's going to be something that used to be not as much of a critical term, but may well be a critical term.
And
Go
so
forward.
married on page 11.
I agree with you. That's a good point. The question was, can seller concessions be put on the first page? And my answer is that's certainly something we can look at.
Okay, everyone, we put John through the ringer, so.